Kia ora and welcome to the second of our webinars on COVID-19 and employment law. This is obviously a distressing time for many of us, and it's an uncertain time for many of us. So by running these panels, we hope to answer some of your questions and provide a bit more information and certainty around what's happening with your employment, your business, and your job. Before I introduce my colleagues on the panel, obviously with the nature of the information and advice that's being provided, there is a disclaimer that we have to give. So Brad, are you able to give the disclaimer, please?
Yes, I am. Look, thank you, Cameron, and welcome everyone. I hope you're all taking care and staying safe and staying well out there, and the sun is shining, so not everything's bad. So it wouldn't be a proper lawyer's do if we didn't give the disclaimer at the start. So I am going to read this one off. So if you see my eyes going somewhere, that's where it's getting. So we're offering the webinar as a free service. It's an opportunity for you to ask questions relating to employment issues during this time of uncertainty. Given that the questions will cover a range of issues today, in many cases we would usually need to review all of the documents relating to employment relationship queries and problems and issues in order to give you specific tailored advice. It's therefore important to understand that our answers today will be general in nature based on the scenarios as we understand them. And I've seen a lot of questions come through already, which is fantastic. Thank you so much. I know you've all got a lot of burning questions, but often a question is only a part of the overall picture. So whilst we do our best to answer your questions, you've got to take away the strong caveat that that is only often a piece of the pie. And to act on that alone in the absence of the broader considerations can be very dangerous. So you shouldn't necessarily rely on the answers we give today to support a legal position that you may want to adopt. Rather, our answers are intended as guidance for you to help you guide you through at this stage. Adopting fixed positions, and I want to talk about this briefly in any relationship, let alone an employment relationship, carries risks, especially in an employment relationship. It carries the risk of claims by employees, i.e. personal grievances, and that's the last thing that employers and business owners want to have to deal with at the moment, along with everything else you bet on. So accordingly, you should always take legal advice about your own specific situation before you draw a line in the sand and adopt a particular stance or position. So wrapping up the disclaimer, I would like to remind everyone listening that employment relationships are founded on trust and good faith. It's the underpinning of the Employment Relations Act. So always remember to be open and communicative with your employees in all matters at this time that you're dealing with them. They're going through difficulties, maybe not the same as you, but it all just takes a little bit of common sense, passion, and good, honest, open communication so people know where they stand. So if you have any doubts, feel free to get in touch with us and take some detailed advice. Otherwise, we hope you find the info we provide today and some of the discussion useful to your current situation.
Brilliant. Thank you, Brad. Now, they say that a week is a long time in politics, and boy, a lot has changed in terms of what has been said by the government and the clarification given. James, can you give us some updates that from the webinar that we did last week until today, what is new?
Thanks, Cameron. A lot has changed in the last week. In fact, no sooner had we finished the last webinar and things were changing already. So I've made a bit of a list here of important major points and points of change. So as I read through them, if anything is not clear to you, then feel free to ask a question in the question and answers time. So the original declaration that was associated with the wage subsidy application was a lot less onerous on employers than the current one. So anybody that applied for the wage subsidy up until 3:59 p.m. on the 27th of March is under the old declaration, whereas the new declaration applies from 4 p.m. on the 27th of March. Now, the points that I go through now, some of these are specifically stated in the new declaration, and other points are points which are common through both that you do need to be aware of. So what has happened on the 27th of March is they have canned the leave payment subsidy. The leave payment subsidy, if you've been watching the media, was originally created to support those who were in self-isolation due to contact or sickness. So what they've done is they've rolled that leave payment into the wage subsidy. So now anybody that was entitled to the leave payment should be paid under the wage subsidy. The requirement for a 30% drop in revenue, or a predicted 30% drop over a 1 month period, and that is where you look at this month compared to the month in the same period last year. If there is a 30% drop, or you predict a 30% drop, then you are entitled to claim the subsidy. It wasn't a requirement for the leave payment previously, and so there's a bit of an awkward situation there. Government has been saying that all businesses are entitled to claim, so we are expecting a relaxation of that 30% revenue decline rule. However, it's very important to remember that at the present it does remain. A lot of people have been saying that they require an actual 30% drop in revenue, and I'd just like to stress at this point that that's not the requirement. It is either a 30% actual drop or a 30% predicted drop. So you should review your management accounts and talk with accountants if you're unsure about whether you meet that requirement or not. Now, only a single application is allowed per employer. So if you've made an application and you left some employees off that application, then you may make an additional application for those employees that were forgotten. However, you cannot make a second application for employees that you've already applied for. Now, you shouldn't be confused about whether you can claim twice as an employee. And what I mean in that regard is if you have 2 or 3 jobs, one where you may be full-time and one where you may be part-time, both of those employers may claim. But the employer, the company usually, would only be allowed to make 1 application. Now, it's been actually stipulated in the new declaration that you acknowledge that all of the obligations under the Employment Relations Act 2000 apply, and that the subsidy doesn't override any of those obligations. So those obligations come through in the good faith requirements, the procedures that are required. You cannot just be dismissing people arbitrarily or unilaterally changing their hours, pay, or leave entitlements. You must follow the rules that are required under that Act. You also make another positive acknowledgement in that declaration that you will not unilaterally change any terms of the employment agreement without written agreement from the employees. So that really does relate even to the 80% rule that everybody is struggling with. If you want to reduce your employees' pay, you must do this by negotiation and obtain their written agreement. If you don't obtain their written agreement, then not only will you likely be in breach of the own employment contract terms, you will likely be in breach of provisions of the Employment Relations Act 2000, but you will also be in breach of your obligations under the declaration. So the bottom line is there, if you're going to change anything, pay, hours, or what have you, then you must do that by negotiation and obtain the written agreement of those employees. You also make a acknowledgement that you will retain the employees for the duration of the subsidy. So you will not take the subsidy and then make people redundant. You will at least wait until the end of that subsidy period and review closer to the time as to whether redundancies are necessary. Next of all, you will not force consumption of leave balances. So whilst you can negotiate with your employees and agree to use annual leave or sick leave balances, it must be by mutual agreement, which I'm just hammering out again. You just cannot force people to take annual leave or sick leave, as it may be. Now the 80% rule. The language remains best endeavours. So what that means is that if your business is closed and you're unable to pay the normal amount of wages to your staff, then you'll make best endeavours to pay them 80%. And that will vary depending on your factual situations, your cash flow, all kinds of considerations. So you don't have to pay 80%, but you must try your hardest and make your best endeavours to get there. And when they talk about what you must pay, they say ordinary wages and salary. Now, ordinary wages are specified as being what was stated in the employment agreement as at 26 March. For instance, if you had an employee who was working slightly varied hours, but their employment contract had them guaranteed 25 hours per week, then that is the ordinary wages, the 25 hours per week. Where you are in a position that you cannot pay 100% of their ordinary wages or salary, then the full amount of the subsidy must be passed on. However, if an employee usually receives less than the subsidy amount, then you just pay their wages in full and you're entitled to keep any surplus and direct it to other staff members. Just remember, it must be used for wages. It's important to realise that MSD have reserved the right in the declaration to amend the terms of the declaration at any time, meaning that they can shift the goalposts or change the rules, and you have to follow those rules. The confusion that stood last week about tax treatment is now clear. This is really something you should discuss with your accountant, but in short, as has been explained in the media, this is exempt income, that is, the subsidy is exempt, so there is no GST or income tax, and when it's paid out, you cannot claim it as an expense. But when paid to the employees, it's paid as a gross amount, and therefore it is akin to gross wages. So it will still have the PAYE deducted, the KiwiSaver, the student loan, the normal deductions that you would process in a normal pay cycle. The $150,000 cap that remained last week, that has been removed. So for larger employers who would have exceeded the $150,000 limit and only received $150,000, you do not need to apply again. The government has said that you will automatically be topped up. So just watch with anticipation. I'm sure the money will arrive soon, but they are under pressure as I understand it. And finally, if an employee should voluntarily resign within the 12-week period in which you're paying the subsidy, then you may keep the subsidy. You do not have to return it to MSD. But if you were to make them redundant, that would be different. You would be in breach of your obligations under the declaration, and you're liable to repay any undistributed amount to MSD. So that concludes my updates and material points, and now I'll pass it back to Cameron.
Thank you, James, for that update. There's a lot there and a lot of changes in a week. We've had a number of you submit questions via email before the webinar, so thank you. We'll be addressing those. Also, if at any point we raise a question or raise a point that gives you a question, you can ask us through the Q&A portion, and we'll be addressing those as and when they come up as well. So the first question that I'd like to throw out to the panel, my business relies on casual employees, contractors and subcontractors. What entitlements can I get to help me support them?
So look, I'll have a crack at that one. So that employer and business owner would be entitled to apply for the wage subsidy for those employees, whether they be casual or part-timers, and obviously for anyone under 20 hours per week, it's $350 per week as a contribution towards their wages.
Can also apply for the subsidy in respect of himself if he's a waged or shareholder drawing drawings. It can apply as a self-employed person.
And I think touching on that, contractors would fall into that self-employed category more likely. There are all kinds of contractor relationships. They might be a company, they could be a sole trader, and it wouldn't be for the employer to make a claim for a contractor in normal circumstances.
Okay. Now, we've also had questions around running the invoicing. It's the beginning of the month, a time when many businesses are sending out their invoices, but of course we're wondering about the ability for those businesses or the customers that we've invoiced to be able to pay them. With respect, we're recognizing that everybody's in the same boat and a similar kind of financial position. So what options do business owners have? Obviously there's debt collection, and that comes with some fairly serious arguments and consequences. If you don't want to go down that road immediately, what options are available for business owners to make sure they still get paid for the goods and services that they're providing?
This is not really an employment question, it's more of a commercial question. But I think it's important for everybody to understand that the law hasn't changed just because of the lockdown and COVID-19. So the ordinary processes that have been suggested, debt collection, they still exist, and you can do that softly or you can do it aggressively. And perhaps what's called for in this time is a bit of understanding and a gentle approach. What's your view?
I'd just like to pick up on that. Having watched the earlier webinar that Godfreys Law ran on property matters, a key theme that emerged from that was communication. That's also a key theme in employment law, as I signalled in the disclaimer at the start, and as James has talked to already. So I think that's going to be really important moving forward, is early and open communication with respect to these matters, to try and work together to find solutions that are going to work. So I would encourage that type of approach. I think it would be dangerous, whilst straying off topic a little here, to maybe use the bury the head in the sand approach and just hope that the money will come in. I think pragmatic steps are required, but that's going to require you to front foot it and communicate and not leave it too long. So I think that's probably about all I can say on it.
There's some normal communication expected from the creditors, from the debtor as well. The debtor, if it realises that it can't pay, should be straight on the phone to you on the receipt of your invoice and saying, hey, look, mate, hard times, I'm going to be a bit slow. Also, don't overlook the fact that your normal commercial terms requiring payment by whenever, maybe the 20th of the month following issue of invoice. They aren't waived, they aren't changed, and people are entitled to rely on them in the absence of any notified changes. The banks have been very vocal in saying that they're there listening, open to negotiation and discussion. The government has put in some backing for business loans, 80% guarantee to the banks, so they're only running a 20% risk. But the banks are also going to be making sure that the business was viable before this incident, before they start lending money, and they must also have a nod to commercial reality. Is this business actually going to come out the other side? But normal commercial considerations will still apply. Your terms of trade will still apply. So you don't send the invoice and 2 minutes later be ringing and saying, where's my money? And that's a two-way street also in employment law, of course. That, you know, if the employee's struggling, the employee's got issues, that employee can't expect the employer to be a mind reader and see inside the head and work out that there's an issue there. It's up to the employee to openly discuss with the employer any issues that they may have.
Completely.
That's great. Oh, sorry, did you have some more, James?
No, I was just agreeing with what Andy said there.
Now, this next one, it may well be a question that you've answered already from the previous webinar, but this one, I believe, is coming from an employee who it looks like their employer has tried to change their employment agreement. So I'm not sure whether there has been any negotiation here or whether they've just been presented with the new one, but they've said being out of the 90-day probation period, the contract has been rewritten to include a further 90-day probation period. Instead of 2 weeks notice required for termination, it's now 4, and with a 6-month non-compete clause instead of 3. So they've asked, is it during this time, is it okay for an employer to alter a current contract? And I'm guessing also with the changes that have been made, if there hasn't been a negotiation process here, what options does that employee have available to them?
Long story short, an employer or any party cannot unilaterally vary a contract without the written agreement of the other party. The alleged imposition of a further 90-day trial period, if they're relying on the fire at will provisions of that 90-day trial, would be struck down. could not be relied upon, and if the employer tried to rely upon it, would be on the very sharp end of a unjustified dismissal clause case, and probably a yell for reinstatement and an urgent application to the court or to the authority for such relief. The normal rules of engagement still apply. You must negotiate, you must get agreement. You cannot unilaterally impose terms on another party.
I agree with you. I agree with you, Andy. So, and just jump in and make 2 comments there. There is often a lot of confusion between a pure probationary period versus a trial period. They are 2 different things. Nonetheless, Andy's comment stands that an employer cannot unilaterally vary the terms without consulting in the written agreement of the employee concerned. And just jumping to the alleged, the proposed or purported extension of the restraint of trade, also sometimes referred to as a non-compete, even if an employee had agreed to that in writing, which I would find hard to believe, I think there are going to be some difficulties there in terms of reasonableness of those restraint of trade periods and the extraordinary circumstances we find ourselves in. So I think any employer who thinks they might go extend restraint of trade provisions at the moment, even if they were to get agreement, may well find that they're unenforceable.
Parliament may have extensive powers in this time of crisis, but that doesn't extend down to employers and ordinary people in business. All of the normal rules still apply, so people don't have the ability to claim an exception to the rule because of COVID-19.
And for this person, if all of this has in fact happened to them, their best course of action would be
Come to
yeah,
us.
look, going back to Andy's comment, and you know, we'll keep reiterating this and hammering it home to pick up James's term, is that the obligation on is two-way street. So if an employer has done something or purported to do something that an employee thinks is wrong or they have concerns about, they're under a duty to alert the employer to their concerns and why they are concerned about the action undertaken, with a view to trying to seek a resolution of those concerns. Now, if they fail at that first hurdle using the self-help remedy, which I think is a great remedy available to people if they are able to, given the power balances at play, etc., and other considerations, if that fails, then at that time I think it's a time to give you know, an employment lawyer a call to discuss your options in terms of what steps can be taken from there to resolve the employment relationship problem.
We've had a number of questions come through around hours being worked, and sometimes there's been a change of hours. Perhaps it's hours on the employment agreement versus hours actually worked, and again doing reduced hours while we're all in lockdown. So there's a number of questions around hours both on paper and actually worked, and what people should be what they should be paid. So I've got a couple of scenarios that have been written, but that is going to be the theme for the next wee bit. This question is, my admin person is required to work from home. However, her hours will be reduced from 40 to 20 due to the close down of the business. So if her normal pay for 40 hours is 1,040, but her reduced hours of 20 means that she's earning 520. The applied subsidy is 585.80. What should this person be paid?
So that person should be paid $520 if the agreement to the reduced hours was done by proper good faith negotiation and agreed to in writing by the employee. If they've agreed to work for $520 a week, then that is what they should be paid. And the balance of the subsidy is available to the employer to distribute elsewhere.
Or to hold to extend the payment to the employee perhaps past 12 weeks.
I suppose that would be fine, yes. As long as the payment is used for wages, that's the only caveat on it.
Or a casual employee who attends as needed, and this staff member helps out on any jobs that they have available. So they're wondering about his hours. Well, what are they? We applied the subsidy from week 1. The subsidy received Monday. Staff have been working till Wednesday. When should they be considered that they're paid up to 80%?
That just because the subsidy has been paid doesn't mean that you can automatically pay your staff 80%. It doesn't entitle you to unilaterally reduce people to 80%. So remember, and that's something we'll just keep repeating through this webinar, is that any changes to the employment terms must be by mutual negotiation and agreement, and cannot be done unilaterally just because the wage subsidy has a figure of 80% being bandied around.
James, with respect, and Andy, with respect to casuals, that's an interesting question in there in terms of how you go about working what a casual might be entitled to under the subsidy scheme.
I saw one question come through, Brad, that said that the person was a casual but was working 40 hours every week, which would seem to me to take that person far from being a casual and more being a part-timer, or but certainly seem to be on a permanent shift of some 40 hours a week, far different from what a casual is generally understood to be. I know that Judge Couch, a former judge of the Employment Court, once pondered as to whether there is such a thing in employment law as a casual employee. That's a question for another day, but 40 hours a week regularly would take, in my view, somebody far from the realms of being a casual. A casual is as required, or the general understanding of a casual worker is as required, as and when required. So there's no obligation to call upon that person if there is no work available. In that scenario, if it was a true casual relationship and the person was working intermittently, that is maybe 3 or 4 hours a month at various times, then there may be no obligation to pay that person at all.
If you claim the subsidy for a casual worker, which you can do, then they've suggested, MSD have suggested, that you average the last 12 months of earnings to work out their ordinary weekly wage. But the only problem is that a lot of casual employees, by definition, might have only been working in the job for a few months. So that calculation is something that you'll have to use your best discretion on, where a casual employee has had the subsidy applied for.
Yeah, thank you. I think there's an important, Andy, you raise a really important point about the, the true nature of the relationship as to whether someone can be, an employee can truly be called a casual employee as and when required. And, that is quite a high bar in my view. The pattern of work has to be, very irregular. And what we often see, the three of us, is many employees described as casuals when in fact they're actually permanent part-timers or permanent full-timers. So that's an interesting thing to look at and consider and be aware of there as well. But I think, James, you offer a good solution as to how a business owner and employer may approach it for someone who could truly be described as a casual in terms of how you might approach paying them.
Yeah, and it goes back to what's contained in the employment agreement, doesn't it? Are there guaranteed minimum hours?
One would hope not in a casual agreement, because if there are, you haven't got a casual agreement.
Okay, this next one comes in from a service provider or a support service for essential businesses, and sometimes their employees are needed to go to perform duties at the premises of their customers, so I'm guessing are the essential service providers. So what are our obligations below? The first one, if the staff member can't go out because they are sick, are they still paid the wage subsidy, or do they then go on to use employee sick leave? And does the normal sick leave procedure apply, like proof from the doctor, etc.?
Yeah, the answer is, in my view, normal sick leave. If they're truly and genuinely sick, and I think that's what the second half of that question is aimed at in terms of the normal procedures applying to doctors' certificates. Just to refresh the law around that, employers can request a doctor's certificate at their own cost for a period of absence less than 3 consecutive working days if they have reason to doubt the veracity of the employee's claim that they're sick and they're not skylarking and sitting on a deck chair drinking beer in the sun at the moment. Whereas for a period of 3 consecutive days or more, an employer can request an employee to provide a medical certificate at the employee's cost to substantiate their claim for sick leave. Again, if they have doubts over the bona fides or veracity of the claim the employee is sick. I think we have to overlay on top of that, in these current circumstances, whether it is safe or reasonable to request an employee to go along to their doctor at the moment to obtain a medical certificate, and whether in fact that's even possible. I don't quite know the answer to that, and that would probably require some careful investigation as to whether an employee could safely go along and do that. My view, taking a pragmatic stance, would be for an employer to, use the trust and confidence they should have with their employee and accept that, at face value in these circumstances. And if the employee has sick leave available, then they can take that sick leave. Otherwise, it would typically be leave without pay in that scenario, unless the parties agreed to some other mechanism to cover that period of leave by some other payment.
That presupposes the question that the illness is something other than COVID. Otherwise, you're not going to see that employee for 14 days minimum.
All right, the next question they ask is, my employee does not want to come to work because of the risk that he would bring to his flatmates and the other people living in the bubble with him, and wouldn't want to go out and then unknowingly bring back the virus or some other illness. Are they still paid the wage subsidy?
Everybody is entitled to the wage subsidy if the employer has applied for it for their ordinary hours of work. It's my view that if somebody unreasonably refuses to go to work, then they would be in a situation where they would be in breach of their contract, and that may jeopardise their entitlement to the wage subsidy. You can't just unilaterally refuse to perform the contract. You have to communicate with your employer, and you have to explain the reasons why you're not prepared to perform the contract. We've actually had some discussion between ourselves about this very issue, because it is a very difficult one to work out, because it would seem that somebody who raises a concern about bringing COVID home to their bubble does have a valid concern. But that would only be in a circumstance where the employer is not taking reasonable health and safety precautions, in my view. What's your view on that, Andy?
That is a question that is very, very fact dependent. As I understand it, these employees are required to not only come into another bubble at their place of work, but they're to go out to other workplaces within other bubbles, which exposes them to further risk. However, they are deemed to be essential workers, and similar to or similar to police, fire, ambulance, medical, other staff that are coming into contact with people from other bubbles, people that are or may be sick, and they have to continue to come to work. Whether or not it's a reasonably held fear of taking it home to somebody who may be a vulnerable person is of course a subjective question and very fact dependent, following an examination by the employer in respect of that employee's particular circumstances. I don't think there's a one-size-fits-all answer to it.
So just as a comment,
I think the court will be troubled with many such applications to try and get to the bottom of when this all shakes out.
so by way of comment, I think any employers watching, if you are offering an essential service, then it's very, very important to consider the safety of those employees. The risk of them performing those services in the current environment is obviously higher, and they should be provided with appropriate PPE. And a failure to do that, in the very least, would definitely bolster the employee's reasonableness of refusing to come to work.
Following on from that, the next one says that if they don't feel, one of the reasons, so the first reason was that this employee did not want to go in because they did not want to expose the people living in their bubble to that risk. And then the follow-up from that is, what if they communicate with their employer just to say, I don't feel safe and I don't want to do it. And I'm guessing that the same caveats that you've put in would also apply there.
Yes, or the only other thing I'd add is that the government have identified an at-risk group, which seems for the moment to be people over 70 years of age or those with compromised immune systems. So if you fit into that category, then it's already been stated that you can stay home, refuse work and receive the wage subsidy. So I think an employer would probably allow that and ought to allow that if you are in that group.
I think again, this would be fact dependent. You would have to make proper inquiry as to what the employee's concerns really are. If there's some underlying mental, perhaps, issue or fear, and there are people that suffer from anxiety, for example, that may fear getting exposed, even though it may seem to be a remote possibility. It's, again, very fact dependent. You need to tread very carefully, I would suggest.
And I would add on top of that, that's a very good point you make, Andy, that employers have obligations to support their employees, none more so than the times like these, extraordinary times, of course. And so if you are on notice or have an inkling that an employee may be struggling either with mental health issue or anxiety issues, as well as maybe valid health and safety concerns, then you should be considering what resources or supports you might be able to make available to that employee to assist them with any fears they may be grappling with at this time. Because let's face it, at the end of the day, when you boil all this down, it comes down to employment relationships, despite it being a contract and a bargain between the parties. The underlying principles of human compassion still must apply. We're all human, we're all in this together, and we've all got to take some time to seek to understand another party's position. Because, as I said in the outset of this, taking stances or adopting stances and flexible stances can lead to a lot of trouble for employers in terms of personal grievance claims down the line. So you've got to use a number of different tools in your toolbox. And what I'm thinking about there is there may be a pragmatic solution available to employers in this type of circumstance, such as we've already discussed, that if they're not eligible for the wage subsidy in this circumstance, well, how about you take some annual leave? Again, the usual caveats we've been discussing. You cannot force them to take annual leave. It's got to be done by written agreement, but there's a further consultation you have with them to look at alternative out-of-the-box ideas as to how you could address this scenario. So you've got You've got more than one blunt instrument at your disposal, I suggest.
Now, one suggestion that we've been given by the government is to stay home and to limit the amount of travel that we're doing. By limiting the amount of travel, we're limiting the amount that we're able to spread, potentially spread any disease. Now, this comes from an employer who wasn't quite set up to work remotely and is asking whether they can have their employees go into the office to either collect or to scan and upload necessary documents or files that are at the office so that they can then go home and work remotely. Would this be in breach of the stay local rule that's being enforced by the police?
Well, the police commissioner was getting a grilling this morning on stuff about the scope of these rules that we keep hearing about staying in your neighbourhood, but I don't think we would want to give advice about that because we're not specialists in it. Watch that stuff podcast if you're interested.
There can be a designated person that's authorised to go in to support officers, such as IT personnel and things like that, that are authorised people to travel around like that to get such things put up for the third party. Perhaps one of those workers could be that designated person.
Okay, well, we've just had one come in, and thank you for submitting your questions both via email and through the Q&A section of the Zoom podcast. This person writes, what if you have taken the wage subsidy for an employee and absolutely do intend at the declaration stage to keep the employee, but the work isn't coming in and therefore it isn't possible to keep them after, say, for example, 7 weeks? Can you start redundancy proceedings, obviously following correct law for the process? How does that work with the remaining 5 weeks of wage subsidy that you have?
My view on that is that it would be good faith communication to be talking with those employees before the subsidy expires to let them know the condition of your business. And if it is going to be that there is no work, then you should certainly be telling them about that. And I don't think there would be a problem with commencing redundancy processes prior to the expiry of the 12 weeks. Just bear in mind that if you were to let somebody go under redundancy before the 12 weeks have expired, then you are in breach of that declaration and you are not entitled to those remaining weeks, and you may need to repay that money to MSD.
Just a question on that, James. What's your view that if there was a 4-week notice period as part of the redundancy and that exhausted the balance of the subsidy period?
Well, I think a 4-week notice can be worked out. So if the notice is given and it's worked out and the pays are made weekly, then I think you could use the subsidy for that. However, if it's payment in lieu of working out that notice, then that's a category that's not actually been addressed. So I couldn't answer specifically, and I would suggest that there is a potential risk there that you may fall outside the requirements of the subsidy. So be better to have anybody work out those notice periods at least.
Garden leave, perhaps?
Yeah, it could be an option. I think my take on what James's view is that he, based on the rules as they're currently stated, there's a the subsidy is for wages. Presupposes that some work has been done, albeit a little. So I guess putting an employee on garden leave, potentially, if they had some duties whilst they're doing gardening leave, but generally gardening leave typically is sitting there at home doing the gardening and not doing any work. So that may be problematic, but we need further clarification on that, I think.
And I do want to state here at this point that this lockdown and COVID-19 is not a convenient opportunity to clear out the rotten eggs and the bad apples. any redundancies are likely to be scrutinised either by an employee bringing a personal grievance, or if the MSD do audit these subsidies, which they have reserved the right to do. So don't be commencing redundancy proceedings and thinking that you'll be able to get away with cutting off the bad sheep. What you need to do is only use them as a last resort, where the financial circumstances of your business are so bad that you have no alternatives.
And staying on this theme of people who are staying home and are unable to work remotely, unable to do anything for the employer, if the subsidy's being paid, does that mean that the employee is accruing time in lieu? And I think what this person is trying to ask is whether or not that they're accumulating hours that they can then give back to the employer.
My view on that is not in respect of the ordinary hours of the employment agreement. So they're supposed to be getting paid the subsidy. It's not their fault that they can't go to work. They're ready, they're willing, they're able to work. I believe that no, the employer would not be accruing time to be used in the future. Having said that, if they top them up over and above their contracted hours and not using leave, if they actually just paid on top to help them out, then there could be an argument that those additional hours could be recovered later.
And you want to make that, if you were looking at doing that, and some employers may well be going over and beyond, they may be in a position to do so, you'd obviously want to get a written agreement recorded around that, so there's no dispute or uncertainty in future. And what I'd also say is I partially take that question possibly to mean, and even if it doesn't, I think it's a good point to reiterate, that employees, whilst they are on the wage subsidy, are accruing leave entitlements. And I agree with James's point that you can't, they can't accrue hours to work back later unless, of course, you're offering them something over and above what they usually get, and then you want to come to some form of agreement around that in writing.
I think the way the question was put, it just sounded like a classic case of trying to double dip.
Yes, it had that element to it.
And that's a no-no.
I think you could run into trouble with MSD if they got wind of it too.
Right. This is the last question we have that has been submitted. So we'll go through this and I'll then throw back to you for your final statements on where we are sitting at in week. Gosh, this is the end of week one, really. Seeing as the first one we did was right at the very beginning of all of this, and then we'll close it out for the afternoon. But the final one that we have is complicated because it has come from the New Zealand subsidiary of a multinational company. It seems that the whole situation, everybody's in the same boat with manufacturing across the world being shut down. But it would seem that the New Zealand branch has gone to the international headquarters to ask for money to top up the wage subsidy to 80% of the wage or salary. It seems that they are being denied, and the head office is asking people to consider using their accrued annual leave in order to top up. How transparent does the company, does the company need to be to staff who are asking why head office or international are not contributing anything?
There are complex commercial relationships here. There may be different company entities, more likely than not, and the employee's employment relationship will likely be with a New Zealand company and not with the head office or the international branch. I could be wrong, but it's not likely to be different to that. And so I don't think there would be a huge degree of transparency that could be enforced, although a good faith relationship would hope that the employer is being as transparent as they can be.
Yeah, look, James, pick up on that. I think my view is that, and I agree with you, there are complex commercial relationships at play there. The relationship with the employees is with the New Zealand company. That will no doubt be the employer, and obviously that's a thing to check. But assuming that is the case, my view with respect to the wage subsidy is that it's clear that you've got to, make best endeavours to pay up to 80%. You've also got to use, endeavours to keep those employees on during that time, which requires you to take positive steps to look at the other alternatives available to the business, to keep the doors open and keep paying your employees for the period. And they are such things like we talked about this last webinar. I think Andy talked about it at some length. Talking with your bank manager and your bank, talking with your suppliers, talking with your landlord in terms of cutting your costs. So, in terms of that overall situation, I think, well, my view is that because the employers will likely know they're a subsidiary company of a global company, unless that company is bound by confidentiality and has received a directive saying, so obviously need to be very carefully there around commercial directives from the overseas parent company as to what they could or couldn't say to their staff. But I think that company would want to be asking the parent company, saying, well, look, we've asked the question of you. You're not in a position to do that. We're under an obligation to be responsive, communicative with our employees and act in good faith. We need to give them information about the steps we've taken at the moment. And obviously one of those is we come to you and ask for some help. You're not in a position to do so. We would like to communicate that with our employees, subject to an agreed message that is suitable to you around that. And obviously that would probably be fairly general in nature. There are just some thoughts there.
I think the underlying question will be looked at further down the track by an independent third party when the dust is settled and some employee takes a grievance and the question is asked of the New Zealand company, or what steps did you take? I think an employer that just says, oh, well, I asked head office for some money and that was it, if that's the sole answer, that those were the steps taken, that employer could be in a spot of bother. That's crystal ball gazing to some extent, and certainly not trying to second guess what a court or an authority member may find. But I would think that as a matter of common sense, that if the government has put in place all of these other channels that you can engage on, and if you haven't gone to your New Zealand bank and you haven't gone to your landlords and so forth, and can't prove that you did, you may be in some bother.
There's also a provision in the Employment Relations Act where this all falls out, and there's a grievance claim, and so it's before the authority of the court. They have the power to assess what resources were available to an employer, why that's relevant is traditionally the court and the authority has held employers with bigger resources, so companies who potentially have a global scope, even a subsidiary of, or big corporates, to a higher standard potentially than a mum and dad operation with a couple of employees. So for those, echoing Andy's comments, totally agree with those comments, and they become even more relevant where we're talking about a big company, because they will be held to a higher standard in the case that proves that.
Against that, they will fight tooth and nail to be held to account as well, and their pockets are probably deeper than the poor employee.
As a starting point, always establish who your employment relationship is with. Once you've done that, you're then suitably armed to go and ask the right questions of the right people.
Wonderful. Thank you to Brad, to James and to Andy for our second COVID-19 and employment law webinar. I believe the aim, given how much has changed in the first week, I believe the aim is to be doing another one next week, where we again will bring you all of the changes and clarification that have been announced by government and Treasury, as well as taking your questions on your situation and anything that's happened in this time. In the meantime, Brad, I believe you've got something that you'd like to say for the people watching.
Yes, thank you, Cameron. And again, I'd just like to reiterate our thanks for taking the time to join us today and to listen to what we've had to say. Hopefully it's been of some use. And we are fielding lots of inquiries at the moment, both from existing clients and new clients or potential new clients. So what I want to put out to you today and your family and friends and those you may know or other business owners or employees, that we want to be able to help as many people as we can at this time. And in light of that, James, myself and Andy will be available to talk to anyone, and we're prepared to give anyone who contacts us half an hour of our time on a no obligations basis to see if we can assist them, basically to listen to your situation. You know, we won't be able to go into detailed specific advice, but it may be that we've got some common sense pragmatic advice that can help you out of a tight spot. And it may be that we've got some ready answers that is the key that you need. And it may be that we identify you need some further assistance, and we can talk about that if that's the case. But we don't want anyone to go without access to legal advice and assistance in this climate. So we're putting that offer out there for people that you can get in contact, have no obligations, half-hour chat with any of the team here on the panel today, and we'd love to hear from you.
By the way, people, just to reiterate how quickly things are changing in this scene, the Prime Minister at 3 o'clock this afternoon announced yet a further class of people that have special payments available under the scheme, and they're essential workers who would normally be required to go to work but become ill or whatever. They are now a specific class within the scheme, but the subsidy levels appear to remain the same. More on that space as it becomes clearer.
Thank you. I would also extend a welcome for you to join us tomorrow, where we are going to be hosting our COVID-19 and commercial property seminar as well. You can find the registration. We will email them out. You can also find them on our Facebook page, Godfreys Law, and we'll be taking questions around lease agreements and what to do if you cannot access your commercial building at this time. Otherwise, on behalf of Brad, Andy, James, and the employment team here at Godfreys Law, thank you so much for tuning in, and hopefully we'll catch you tomorrow for our commercial property webinar. Thanks for joining us.